company securities and insolvency law, recent regulatory and legal updates. As you are aware, first week of every month, our webinar is based on what has transpired in the regulatory world during the last month up till the date of the webinar. And we discuss the latest amendments, changes in other regulatory framework, any specific case laws and other related things as part of a recap in this webinar. So today I have a galaxy of speakers as always, starting with we have Mr. Amit Gupta, who is a PCS and insolvency professional. He has been a regular participant to our webinar, so I don't think he needs any introduction. Then we have Ms. Anjali Agarwal. She is the partner and head at Capital Market Services. Then we have Mr. Manoj Kumar, who is partner and head M&A and transactional corporate transactions, corporate professionals. We have Mr. Ravi Prakash, associate partner, securities law and corporate litigation. Then we have Ms. Uchika Sharma, who is also associate partner at corporate professionals, and Ms. Nikita Vijay, who is a senior associate and works under the corporate securities and corporate litigation team. So I welcome you once again. Last month has been an eventful month because both at MCA, we are already aware the kind of chaos that is there onto the new portal, the new changes that have been there, and those still persist as on date. And also because of the kind of activism we have found with the Office of SEBI, who has been working like anything and at a rocket speed, or I can say a light speed, as we saw more than 17 discussion papers coming out of SEBI during last month only, and there were some discussion papers that were also there in the month of January, and some might come in this month too. And all these discussion papers are very important. The proposals, they are sought to bring key regulatory changes, both with respect to corporate law, listed entities, mutual funds, and a lot of other market intermediaries. So today we will also discuss in brief some of the key proposals that are important from the perspective of listed entities, so far as they are related to changes in LODR regulations or ICDR regulations or ESG framework, apart from other recap of other regulatory changes in corporate and securities law. So without wasting much time, I'll just want to reiterate you that all these updates that we discuss in today's webinar and otherwise also forms part of our fortnightly journal, CP Connect, that we share on all the social media channels of our, and also share with all the participants who keep on attending our various webinars. If you are receiving, it's good. If you're not receiving our CP Connect, you can drop us a mail at info@indiacp.com. Sharing the details of your email ID, we'll make sure that you also start receiving the same in times to come. So I'll start with the with corporate law, starting with amendments in the Companies Act. So I'll request the team if they can put the slide on to discuss the key changes. And then as I go, I will keep on introducing the relevant panelist to share his views on relevant topic of discussion as part of the presentation. So starting with the amendments or recent changes under the Companies Act. So can you move, Shivam? So there were no specific amendments per se, but what we seen during last month is just continuation of something which happened in the month of January with the introduction of the new version 3 portal and conversion of around 46 e-forms into the new way of filing the forms. We saw that there was a hiatus in the system during 7th January till 23rd January, and thereafter the new system was rolled out. Post that, we have seen that professionals and corporates at large are facing widespread issues in filing various forms and dealing in many ways with the MCA portal. Though every change, there are issues connected with changes, and it's not easy to adopt change, particularly when it comes to something as big as MCA. And I think ministry is also trying to make up things and working at a good speed and trying to do things to ease the life of professionals and corporates. But I don't think much is being done. And My team also continues to face similar problem as all professional friends are facing in the industry. So what ministry did as part of the relaxation in filing processes on account of difficulties that are arising due to the technical issues in the version 3 forms, ministry extended the time for payment of additional fees in case your due date is falling between 7th February starting from 7th February to 28th February. I believe this date should also include the date that was earlier there, where the time was 7th January to 23rd January. I still see a lot of companies are even not able to file those forms that were due for during that period. But as of now, the due date, extension due date for those period falling between 7th January to 23rd January have already been expired, and the current timeline of relaxation in terms of additional fees is only available for the filings which is falling due during 7th February till 28th February. Similarly, while PS3 was, I think, not rolled out under the new system, but on account of changes in other forms, PS3, there is also issue which is ongoing, and there is those who are filing between 20th January till 28th February, their additional fees is also extended till 31st March. So in both the cases, the additional fees has been waived off till 31st March if you file on before 31st March and due dates are falling between these dates. With respect to the name reservation, if your name is currently reserved and it's about to expire, then you also have been granted an additional period of 20 days. Similar timeline of 15 days is also awarded to all the resubmission requests for name change, name availability, which is pending with the MCA during this period of 23rd January till 28th February. If there is a resubmission which is falling, then also you are being given an additional timeline of 15 days to comply with the resubmission request. Then there are various other forms where due to the version 3 filing, these forms were not able to file on the portal. So therefore, and because of this, a lot of activities were stuck. Like for example, in case of allotment of shares, companies were not able to utilize the proceeds. Similarly, in case of SH8, SH9, companies are not able to complete their buyback process because you cannot open a buyback unless and until the letter of offer is filed with the registrar of the companies. So considering the difficulties that corporates and professionals were facing, ministry came out with another circular allowing companies to file these forms, which is listed out here: GNL2, MDT14, PS3, SH8, SH9, SH11, all related to buyback. You can file these forms physically with the office of the registrar of the companies in whose jurisdiction your company is falling, without any fees. And once I believe the system is restored, then you will be allowed to file these forms by way of a separate filing mechanism, which will be clarified once the end date is passed on. So I believe these are the key changes with respect to Companies Act. I now invite Amit to share her views on these changes in the regime of non-convertible securities governed by SEBI. Amit, you are there?
Yeah. You're asking me to explain about
Yes.
these changes. So
Yes.
what I understand, the changes are primarily relating to twofold. One, they had extended the nature-based raising of funds. Like earlier, they had came out with the option of green debt securities. Now they have introduced the new concept that if you are doing something in relation to the water management, or you are in the marine sector, or if you are in a solar sector, then you are allowed to raise the specific color bonds, like blue bonds for the water related and marine sector, and similarly yellow bond for the solar energy. And there are certain transition bonds also, which are a subcategory of the green debt securities. So in a way, government is creating more and more awareness for the sustainable finance, which is for preventing the pollution and bringing the eco-efficient product in the market. And SEBI has also came out with the certain do's and don'ts for the greenwashing. Shivam, will you move to the next slide? There is one more change with regard to the non-convertible security, because the problem, I believe we and Ankit has been discussing, that whenever we go for issuance of non-convertible security, the situation was like that as against the provision of equity, where the minimum timeline and maximum timeline for which the issue was to be open was prescribed. But in case of these non-convertible securities, these timelines were not provided for. So now government has amended the regulation, and they have prescribed that the issue will be open for minimum 3 working days and maximum 10 working days. So that is the standard timeline that has been provided. And regarding the green debt securities, to avoid the occurrence of greenwashing, the obligations had been casted that the company is required to continuously monitor to check whether the path that has been undertaken towards more sustainable form of operation, which is resulting into reduction of adverse environmental impact and contribute towards the sustainable economy, is being maintained or not. Then also it has casted an obligation that it will ensure that the funds are not utilized for the categories that would not fall in the definition of green debt security. And also, in case instances which are coming to the notice that there are deviations, then it will be disclosed to the investor. So these are 3 measures which are provided by the regulator in respect of the greenwashing concept. And in addition to that, they have also prescribed that they will not use any misleading labels, or they will hide trade-off or cherry pick the data from the research to highlight the green practices. So that cherry picking is not allowed, although displaying about what is the factual information is not barred, as far as you are promoting or you are applying the green bonds proceeds for sustainable growth purpose. And another obligation that has been casted is to maintain the highest standard which is associated with the green debt security. And it will qualify the negative externalities which are associated with the utilization of funds which are raised through the green debt security. So bottom line, that remains the concept with which the green debt facility was introduced by the Securities and Exchange Board of India to prevent any possible misuse by the industry. The government has on a preemptive basis came out with certain directions with do's and don'ts, so that industry does not adopt any unfair means for misusing all these things. I think Anjali is there. Maybe I'll request Anjali to throw certain further aspects if there is anything which is intent behind, and that we need to take care in respect of these two new bonds which have been introduced, that is blue and yellow, and also the greenwashing concept what has been introduced for the non-convertible for these bonds, green bonds. Anjali ma'am?
Anjali, ma'am, you have any views? I don't think she's here.
I think we can proceed with, and we can take further. So Ankit, you want me to continue with this?
Yes.
All right. So another concept that was introduced by way of a clarification, that SEBI has came out with the clarification with respect to the issuance and listing of the perpetual debt instrument and the non-convertible preference shares and the other similar instruments in the Chapter 5 of SEBI issue and listing of the Non-Convertible Securities Regulation 2021. And it is mentioned that only the securities which have the characteristics as stated below shall necessarily be required to comply with the provisions of these regulations. And number one is the issuer is permitted by Reserve Bank of India. The instrument forms part of the non-equity regulatory capital. And third, that these instruments are perpetual debt instrument or perpetual non-cumulative preference share or any other similar instrument. And lastly, it talks about that the instruments contain a discretion with the issuer or the Reserve Bank of India for events including but not restricted to all or any of the below events, like conversion into equity or write-off of the interest or principal, skipping or delaying the payment of interest or principal, or making an early recall and changing any terms of the type of instrument that can be issued in this particular regard.
So even on the perpetuality, I believe only in most of the cases, banks have been permitted to issue perpetual instruments, considering their requirement to meet the Basel III norms with respect to the capital.
Correct.
Because under the Companies Act, you cannot issue irredeemable preference shares.
Correct.
And under the regulations of non-convertible securities, though SEBI has introduced this concept of perpetual instrument, I believe that has been issued or brought in the amendment regulation. Considering there are these big banks who are issuing these kind of instruments.
Ankit, I believe absolutely you are bang on, because the conditions that they have specified also indicates that the issue is required to take a permission from the Reserve Bank of India. So it will not be possible for the other entities to come out with the issuance of and listing of the perpetual debt instrument or perpetual non-cumulative preference shares instrument. That instrument primarily is going to be utilized by the banking industry, as you have just now indicated. I don't see that there would be any other entity. I don't know whether NBFCs are going to be in a permitted category or not. But as of now, if they are allowed by the Reserve Bank of India, then perhaps yes. But I think we need to get into more details to give that view, whether such kind of other than banking companies also, like non-banking finance companies and other entities will also be allowed. Because as you rightly mentioned, because Basel III requirement and other three norms are not there. So perhaps there seems no as such requirement as of now. But yes, we can read through the finer details to understand whether which kind of entities are likely to be benefited out of this particular clarification.
Shivam, next.
Then another clarification which has been introduced by the SEBI is with respect to the compliances by the first-time issuers of the securities under the SEBI issue and listing of the non-convertible securities. And SEBI has advised to the stock exchanges to take an undertaking from the first-time issuers that they will ensure their article of association are amended within the period of 6 months from the date of listing of the debt security. So this kind of undertaking is now going to be a prerequisite whenever you are going to have your first listing of your debt security. And as they have accordingly modified the requirement that this will be required to be obtained at the time of granting in principle approval. And issuer shall within such time comply and report the compliance to the stock exchange, which shall periodically monitor, remind such issuers on doing the needful. So this is one requirement, that articles are required to be amended, and necessary undertaking is required to be provided at the time of first listing, and precisely at the time of grant of in principle approval by the respective stock exchange.
So, but this is more with respect to the amendment in respect of the right to appoint director by the trustees. Is this
Yes,
amendment?
it is in that backdrop only.
Your last topic.
So so another change that has been introduced is regarding the issuance of summary document and dissemination and the advertisement. So SEBI has introduced the issue summary document for filing papers pertaining to the initial public offer, and for further issue of securities in XBRL format. This move is likely to provide to the stakeholder a data in much more structured format. I don't know what about the shareholders, but I think idea is that stock exchanges wanted to collect and collate the data in a scientific manner, as they have been moving in respect of all the filings from PDF format to XBRL format. So they have extended this particular requirement also for these particular documents also. So which will definitely, it will benefit to the other stakeholder also in form of getting a more structured data. But definitely it is going to be for the more better monitoring and compliances by the stock exchanges respectively. So first phase will start from 1st of March 2023, which has already commenced 2 days prior. If any company is coming out with the public issue on or after 1st of March 2023 for the certain specified security, and second phase will start from 3rd of April, and third phase will start for certain open offer and buyback and the voluntary delisting. So all public issues, I understand, will have to have the compliance mechanism in place. So whosoever is going to come with a public issue, I believe the issue opening date or it should be, I think, filing of offer document date that will, if it is 1st of March 2023, then it will be required to do this particular compliance. And for further issues, they have given the time of another 1 month, that is 3rd of April. And buyback and the voluntary delisting will be coming from 2nd of May 2023. These are the Yes, Anjali.
In addition to what Amit said, if we look at the structure of the information which is needed to be given in the ISD document, it is a very, very simplified structure wherein anybody and whomsoever wants to understand about a particular issue can understand in a very, very simplified term as to what is the size of the issue. Otherwise, one keeps on struggling through the entire set of the document. The offer document is approximately 200 to 300 pager document. One keeps struggling where to get what sort of information. So this ISD is a very simplified 2-pager document which everybody can understand and assimilate very simply in a simplified manner.
Yeah, but the million-dollar question remains whether it will contain only the vital information or the other information also, which is forming part of presently the offer document, as to what all will be, whether this will suffice the information requirement of a shareholder or not, is a question that keeps hovering to the mind of the professionals. or will they be required to refer the offer document also in addition, or there is a need that this document also need to be made little more comprehensive to meet the requirement of the expectations of the stakeholder also. Ankit, you are mute, I believe.
Sorry. I'm sorry. So I'll now request Anjali ma'am to take the matters related to updates under securities law, starting with the recent circular on minimum public shareholding.
So the first circular which we are planning to discuss today is the MPS compliance, minimum public shareholding. We all know that a listed entity has to have a promoter who has to have a public holding of at least 25%. But even as on date, there are approximately 100 companies wherein the promoter holding is more than the 75% threshold. Already there are 6 modes which have been allowed by SEBI to comply with this MPS. This is just to enumerate what modes are presently available. This is offer for sale, offer of shares through the issuance of a prospectus, or offer for sale through prospectus, offer for sale through the stock exchange mechanism. This by and large has been the most utilized mode for the purpose of complying with MPS. Whatever number of companies have complied with MPS have majorly used this mode as the mode to comply with the MPS. Then rights issue to public shareholders or a bonus issue to public shareholders. These 2 modes are also applicable, wherein the promoters will have to forego their portion of the rights or the bonus, and the offer will be made only to the public shareholders. Allotment of equity shares to the QIBs, or any other mode which SEBI may allow on a case-to-case basis, wherein the company will have to make an application to SEBI, and then SEBI may grant additional mechanism to comply with MPS. Now, by virtue of this circular, SEBI has allowed additional modes. SEBI realized, and there were representations made to SEBI that certain additional modes are required to comply with the MPS. So the additional modes which now SEBI has allowed is, first of all, ESOP. We all were also feeling that ESOP, because it is being allotted to, shares are being allotted to the employees of the company, and employees are not the part of the promoter of the company. So ESOP should be allowed. So now SEBI has allowed, by virtue of an ESOP scheme, the MPS can be complied with, but this is subject to a maximum of 2%. And again, the condition continues that the allotment will not be made to the promoters of the company. But I think one thing which might have to be looked into, that in case of any ESOP scheme, there is a vesting grant and vesting period of at least 1 year. Then that would mean that the compliance would happen 1 year after the ESOP scheme has been initiated. Which may not be the intent of SEBI. Probably this needs to be looked into. Then the other mode which has been allowed by SEBI is transfer of shares to the exchange traded funds. So these exchange traded funds are funds managed by SEBI registered mutual funds. So with regard, if a particular company wants to do that, the promoter will have to give his intent to transfer X number of shares to the ETF. And also, this has to be done with at least 1 day prior to the proposed transfer. And it is again mentioned that the company will not be allowed to buy the shares of the funds to which the shares are being transferred. Shivam? Yeah. So, in addition to this, they have allowed for an open market sale. Presently, up till 2% of open market sale, 2% of the paid up capital of the company is allowed, even under the present norms. But this 2% has been increased to 5%, subject to certain conditions, that the public shareholding should become 25% after the completion of such sale. This should be concluded within a period of 12 months from the date of first transaction. It can be in a single tranche or a multiple tranches. And accordingly, the MPS can be complied with.
Ma'am, and
There have been
ma'am, I just
overall
want to-
changes in the buyback regulations.
Am
We
I
will not
audible?
be covering here in too much detail. In fact, we plan to have a complete webinar, separate webinar with regard to the buyback of securities and the amendments that have taken place. But to give a brief gist of the amendments. So first of all, under the tender offer route,
audible?
it has been decided to reduce. I can't hear.
Ma'am, can't you hear me?
Yeah, tell me.
Okay, I thought I'm on the MPS. Any other option left?
Sorry.
On the MPS, any other option that is left that can be introduced, or any?
That can be introduced.
Yes.
If you'll ask my opinion, I feel that even a preferential allotment should be allowed. To non-promoters, preferential allotment should be allowed. There can be certain additional lock-in conditions in that respect. There can be certain additional, SEBI may impose certain additional conditions, but it should, even preferential should be allowed.
And any issue that you foresee in the new additions that have been made to the list?
ESOP, I said that because,
like for example, ESOP, where
yeah,
ESOP
that's what
in a very minuscule percentage of the total paid up capital, will they in any way help companies in achieving MPS?
See, ESOP can be utilized only up till 2%. Not more than that. In any case, SEBI has allowed only 2%. So if presently the promoter holding say 80% and the portion to be diluted is more than 2%, then ESOP can be just one of the modes. Probably OFS would continue to be the main modes to comply with it, but in a situation wherein the promoter holding is 76%. And the issue to be brought down is only 1% or 2%. Then in that case, yes, ESOP can be utilized as a good measure to comply with it.
And what if in spite of multiple OFS in the market, or even attempts on the promoter to sell their stake to the percentage allowed under these modes, if the company is not able to achieve MPS on account of reasons beyond their control, so do exchanges give them extensions or waive of the penalty?
No. There is a penalty provision at the rate of 5,000 rupees per day. So that notice would obviously be coming. But on a case-to-case basis, of course, exchanges have the power to waive off the penalty. So wherein exchange will try to understand that what all efforts have been made by the company during the 1-year window that was allowed to it to comply to whether the efforts made were just for namesake, or actually they took the efforts to comply with it, and still in spite of repeated efforts, MPS could not be complied with, they may grant to waive. If not complete, at least partial.
Okay, thank you. I buyback changes.
Yeah. So, as we were discussing about the buyback regulations, first of all, it is proposed that under the tender offer route, there would be reduction in proposed timelines of the entire buyback issue. This is tried to be achieved by way of the requirement of having filed the draft letter of offer with SEBI. This requirement has been done away with. Now the letter of offer is needed to be prepared by the merchant banker and straight away filed with the stock exchanges and to be dispatched to the shareholders. SEBI approval has been done away with. Plus, a very important provision which has been promulgated is upward revision of the buyback price. In many of the cases, it was felt that the company, when it announced the buyback, the price was say 300 rupees, 400 rupees. But by the time the stage used to come for opening of the issue and the tender offer buyback price was proposed to be 350 rupees. So by the time the stage for opening of the issue used to come, the price was already in the range of 350 or many a times had even crossed the level of 350. So meaning thereby the entire process of buyback becomes infructuous, and obviously nobody would be tendering the shares where in a situation wherein running market price is also 350 and you are also buying back at 350. So SEBI has allowed upward revision of the buyback price, subject to the condition that the total buyback size would remain the same. And you can increase the buyback price, meaning thereby there would be a reduction in the number of shares proposed to be bought back. Open market route, it has been decided to do away with the open market route in a phased manner. So by 1st April 2025, the open market buyback would be totally done away with. Under the present norms, there is a provision under the open market route that the amount of decided for buyback, if it is reached 50%, at least 50%, the company has an option to withdraw the buyback or close the buyback. It is proposed to increase this 50% to 75%, and then only the buyback offer, once announced, once initiated, can be closed back. Then under the open market route, there is no requirement of obtaining any separate acquisition under the present laws. There is no requirement of obtaining a separate acquisition window from the stock exchanges, but it has been promulgated now that a separate acquisition window will have to be taken even for the open market buybacks. Plus, it's not mentioned here, but in addition to the open tender route and the open market route, it is proposed that the book build buybacks, which have been there since for ages in the buyback regulations, but have never been used. Not a single company has used buyback by book build method. So it is proposed. SEBI has decided to streamline the process of the same and has brought in certain amendments with regard to the provision for book built buyback.
Ma'am, two questions.
Shivam?
Am I audible?
Yeah.
So two questions. Any reason for phasing out this? And secondly, why they've given a timeline of 1 year? Or even, I believe, yes, 23, 24, even 2 years. 2 years.
2 years.
So why they've given a timeline of 2 years if something...
So phasing out, to why they have decided to phase out the open market buyback, because in open market buyback, what we see is the company announces a particular buyback price, but does the buying at or near the running market price. So if I announce a buyback price of 400 rupees, but I'm doing the buyback at or around 250 or 300. So that 400 is virtually infructuous, is giving a picture to the market that I'll be buying at 400, but you're still doing at 250 rupees at or around the running market price. So it is felt that book built issues may be better able to serve the purpose or in terms of investor benefit. And that is why it is decided to do away with this thing. And secondly, why this 2-year period has been given, that number one, for the companies which have already announced their buybacks, for them, probably keeping those in mind. But till 2025, yes, that can be a question. Why till 2025 this window has been allowed?
Amit, any thoughts you have on this?
I'm also not able to figure out the reason for gradual phasing out. I think it is just to give a timeline to the market to consume these changes, and it should not be a knee-jerk reaction kind of thing. I think market should absorb, because these things have been into practice for quite a long time. There is one more point which I want a comment from Anjali ma'am. There was a recent talk and there was a discussion paper also with regard to the buyback taxation. And there also this similar talk was there just to avoid the disparity in the buyback structure, where at the cost of general public, the certain peoples are benefited out of that. So the buyback taxation should also be put at par with the dividend taxation. That is, it will be taxed in the hand of the receiver instead of company paying the taxation. Because if a company, let us say buyback is made and 20% quantum comes to 1 crore, then this 1 crore is charged to entire group of shareholder, not to the people whose shares are bought back. That was an issue perhaps due to which this proposal was mooted. So I just wanted to know, is it going to be synced with that? Because after that, we have not heard anything. I'm not sure where the proposal is lying today, because we were expecting in the current budget also that there will be something which will be announced on the same. And many companies, to be very honest, have already planned their buyback also prior to 31st of March in that particular background. So I just wanted to what is the status as on date? Any insight that you have as to what is the plan that government is going to do with regard to the taxation perspective? Though I know it is a not.
I know it's we'll have to.
Will be there. I think it escaped.
No, actually, this was one of the proposals in the discussion paper which SEBI had floated about 2-3 months back. But after that, there is no update on it. And because this requires an amendment in the taxation laws and has to be proceeded through the union budget, probably that is the reason why it is not been decided as of now. And it has its own implications, you know, till if you make buyback in the taxable in the hands of the shareholders, so then the very object of anybody subscribing, anybody tendering the shares in the buyback, the person may lose the charm. Anybody doing the sale in the market versus tendering and paying taxes, people may lose, the entire security may lose its charm. The entire corporate action may lose its charm.
So that is their entire argument. That is what they are saying, ki why the person who is tendering his share, he is benefited at the cost of the other person who has not tendered. Because the tax is spread out across the all people.
Amitji, in this, there are many aspects, not the single thing. We cannot charge everything, full value of buyback shares as a dividend, because it is obviously it has to be linked with the income of the company. It is not a capital. The capital account transaction should not be taxed as a revenue account transaction. So only the accumulated profit portion of buybacks, bought back share may be charged as dividend. Rest of the thing need to be charged as a capital gain. Then in case sale of securities in the market, long-term capital gain tax rate is 10% and short-term is 15% subject to STT. Whereas here we need to split the thing. Ownership period need to be, holding period need to be adjusted. So all those adjustments need to be made, and based on that taxation need to be calculated. So it is not easy, and that's why the easiest format was to have single person from which tax can be recovered by the company, by the government. And hence this provision had come. Earlier also DDT, dividend distribution tax, was meant only to reduce the burden that hundreds of people making tax return or not, filing tax return or not. It is better to have it from the one person, which is the company which is distributing. It was simpler, and it was also non-complicated and not avoiding the leakage of the tax. Now, because the rate of tax in the individual hand is much higher, we think this is a disparity, but that is not the case. There may not be everything which is taxable as a other source of income. It should be capital gain also. So adjustment would be required, and hence this matter is getting deferred every time. It is not easier to implement.
So not coming at least.
I don't think it is coming in very soon. Yeah. Unless all other taxation provisions are aligned, capital gain rates are also aligned, and all those things happen, it will not come easily.
All right. Ankit, one question to you also, because you do a lot of transactions with regard to the buyback. There is one consistent discrepancy with regard to the views with regard to the 25% threshold. whether that is with regard to the quantum that can be utilized for the purpose of buyback, or it is a quantum of shares. I think there is a wide variety of practice in terms of the various registrars. Maybe the registrar sitting at Karnataka is having a different view, maybe sitting in UP is having a different view, and Delhi is also having a different view. Similarly, Mumbai is also having a different view. So two views are prevailing. One is saying that 25% threshold is to be followed for the number of shares also. And the other view is that that number of shares are no longer restricted because there is a significant change in the legal framework vis-a-vis 1956 Act. So number of shares restriction does not apply on a 25% cap. So what is the call that you have taken, or how we are dealing with the different set of registrar while advising the buyback transactions?
I think, sir, if you read the language, from the language, it is very clear it is on the amount, not on the number. But almost of the clients, those we deal with or other professionals, those I speak, they have taken a middle path, 25% on both sides, number of shares and on the quantum of amount. But if you read the language and where the law says you have to read it with respect to the equity shares, it can only be said to be read in terms of the quantum of the total amount that has to be used for the purpose of buyback, not on the number of shares. And though a company cannot survive without a share capital, so it's not possible that you can buy back the entire 100% share capital. You have to leave somewhat. But even if you buy back 99.99 and leave one share at each for all the shareholders, 7 shareholders if it's a public company, or 2 for a private company, it works because there is no requirement of these days of even having a minimum paid up capital, which used to be the case earlier. So it appears to be in terms of the quantum, but as I mentioned, safer route is to take on both the sides, on the quantum and on the numbers.
In case of listed companies, this amendment has clarified that it is on the number of shares.
Okay, the increase that they have proposed, I believe, now there is a increase in the limit also. Now that is, I think, in
25 to 40%.
So that is in number.
But yeah, this is in numbers.
Okay.
Okay, thanks, Anjali ma'am, for sharing your views on the buyback regulation and the MPS. Now I'll request Ms. Nikita to share us the recent changes with respect to REITs and InvITs.
Thank you so much, sir. Very good evening to all of you. So with respect to the updates regarding the REITs and InvITs, I would just like to give you a little background. So basically, REITs and InvITs are kind of a special purpose vehicle arrangement where people can invest in the real estate and the infrastructure investment trust through units. So this is the regulation has come back in 2014, but REITs and InvITs were on a very nascent stage and has been evolving since then. Earlier, there was not much involvement of investors and there was not much investments by the retail investors. But recently, if you see the statistics, there are 5 REITs and 19 InvITs which are registered with SEBI, out of which 3 REITs and 15 InvITs has come with the initial and further public offer, which amounts to 20 REITs and approximately 90,000 crores market through InvITs. So considering the increased investments by the investors in these kind of setups, SEBI wanted to specify the governance norms on these setups also, like in the listed entities. So if you see as a basic, the basic basis of this amendment is to apply the corporate governance provisions to REITs and InvITs as it is applicable to listed entities under SEBI regulations. Can we move forward? So if I just consolidate the kind of amendment that had come under the REITs and InvITs, so there are the REITs and InvITs amendments are divided into 2 aspects. So one amendments are immediately effective, which is generally related to the appointment and reappointment of the auditors. Now they have to appoint the auditor whose tenure will be until 5 years. The scope of audit has been increased, that they have to undertake the limited review of audit as in the listed companies also. Then REITs and InvITs also required to follow the same practice to have a closer view on their financials. Other than that, they have also prescribed for REITs and InvITs, they have to maintain the outstanding borrowings with respect to their threshold that they have to maintain vis-a-vis their assets in the REITs and InvITs. So with respect to the with the point of view of the liquidity, the overnight mutual fund which have expiry of 1 day, so they have suggested that they should not come under the definition of assets for the for calculating these leverage thresholds to have the borrowings in the REITs and InvITs, as they are equivalent to cash and cash equivalents because of their liquidity. Further, they have also provided that any unclaimed and unpaid distributions which are to be to the unit holders of the REITs and InvITs, they have to be transferred to the IPF account that has been constituted by SEBI. So if you see, most of the amendments and the norms are being applicable to REITs and InvITs as they have been applicable to listed companies to secure the investors' interest and to protect their investment in such kind of setups also. Other than that, in general, they have also provided norms to provide an independent director on the board of the REITs and InvITs. They should also have one woman independent director. There are specifications with respect to what should be the minimum quorum of the meetings of the board of directors. And they have also prescribed that they should also form committees on the board of these REITs and InvITs. So they have to form the audit committee, the nomination and remuneration committee, and stakeholders committee also. In addition to that, they are also required to follow a code of conduct. They have to frame a code of conduct for their directors and senior management and the KMPs of REITs and InvITs, so that how they should follow the working and the operations of the REITs, and so that no investor loss is happening, to ensure more watch on the investments done by the REITs and InvITs. They have also considered to provide a code of conduct for their senior management. Further, in addition to that, there are certain secretarial that they have to provide a secretarial compliance report to the stock exchange within 60 days. They have to provide the quarterly compliance report on the corporate governance norms, which they have to intimate to stock exchange within 21 days from end of each quarter. Next, please. So, other than this, there have been two very important judgments also. So, with respect to the
InvITs, I believe so. Most of the key provisions of LODR regulations have now been applied on them.
So previously there was slight of a confusion, you would say, or a very limited applicability of LODR on REITs and InvITs. Only REITs and InvITs who have listed debt securities were required to follow these LODR provisions. But now,
listed securities.
Yes, so now they have uniformly they have said to apply it to all the REITs and InvITs
who are listed.
Yes, sir. Shall I move forward?
Yeah, please.
Yeah. So other than that, there has been a fiasco regarding the Adani share prices due to volatility happened in the Adani share price due to the Hindenburg research report, and there is a ongoing writ petition case which is going in the Supreme Court. That so basically the concern that has been raised in this writ petition was basically how to protect the investors' money when, because of one research paper, there has been thousands of crores of loss to the retail investors. Because we all know that during COVID, the lot of retail investors happened engaged in the stock market, which was a landmark thing with, and now due to this volatility in the market, due to a research report, there has been loss of investors' money. So raising this concern, so the writ petition basically deals with it, but that this thousands of public money is at risk. So what they have requested the Supreme Court to form a committee to investigate the matter properly and to see and how to. They have also sought a instruction that they should form an expert committee. We should see the existing regulatory framework to avoid these kind of volatility in the future, because they are resulting in a lot of loss of public money. So in the SEBI has also provided their submissions that they are currently investigating the matter related to the Adani group violation that has been alleged by Hindenburg. They are considering that whether there is any weightage in the allegation that has been alleged by the Hindenburg. And there is also, they have submitted that they are investigating the matter, and they have said that there are already certain things which are in place. For example, there are mandated disclosures by the listed companies to facilitate free and fair price discovery, and market system to ensure seamless trading, enforcement action if there is any misconduct. But what happens if such kind, because today media, social media, everything is so outreached, it's so worldwide accessible to everybody, that's it's very hard to protect the public investors' money, and it's very sensitive that one small news comes and the share price fluctuates a lot. But there is so there should be a mechanism to protect the investors' money. That's what the concern about. So there have been two directions in the matter that they have. Supreme Court has directed SEBI to conclude their investigation in 2 months and provide their report to the expert committee. And an expert committee has been formed by the Supreme Court, which have top-notch people who are Supreme Court judges, and has securities market experts also. And they have said that they should overall assess the matter regarding to the Adani fiasco, and they should also provide their report in the 2 months and see what are the necessary regulatory changes which are required to curb this kind of investors' loss and to protect the investors in such kind of cases.
And
So,
any
yes.
update on the, are you aware of the recent Supreme SEBI judgment in the matter of the YouTube channel?
Yeah, I was coming to that only, sir. So I think as I said, that social media, YouTube channel, they're so accessible to everyone that they have also and nowadays financial influencer is a new norm, which is very trending right now. And SEBI also discussed a few months before that they want to come up with the regulatory provisions to control these financial influencer. And with respect to this, recently 2 cases in the case of Sadhana Broadcast and Chapline Broadcast, there are 2 scripts wherein pump and dump has been done by these through these financial influencers. And so basically the case was all about that they uploaded videos and they recommended to buy these shares, and they have the price at that time was 19 rupees, and they have said that it will go up to 340. And since there are a lot of retail investors, and we see it in around us also. We see our parents or we see our relatives that they see the YouTube and they share with us that this stock will go up. Some influencer and some educator is advising us. So it is very common practice which has been followed by these YouTube creators, and it has a wide reach. Those channels has more than 8.97 lakh subscribers, which had actually created a volume in these scripts, and then the price was increased, and many related, it is alleged that many related entities took the exit after the price was, and the retail shareholding was increased during this period. and the persons who were already holding more than 2 lakhs were their shareholding proportion went down. So it shows that it was a pump and dump case, and there are a lot of, so SEBI has actually received complaints regarding this. So after that, they have investigated this matter, and it is very common. So it is very important as a layman and as an investor to be cautious before following these financial influencer. SEBI has already put in a place a framework of registered investment advisor. So it is always advisable to get these kind of investment advisory and recommendation through registered investment advisors only.
Thank you. Thanks, Nikita, for sharing.
Thank you so much, sir.
Now I'll request Ruchika.
Yeah, Ankit, Ruchika is not there.
Okay.
So I think there was a small move with respect to the takeover regulations. So the present takeover regulation has come in 2011 after the recommendation of Achutan Committee, and based on that, the old 97 regulation was replaced with 2011 regulation. After that, there has been several small or big amendments. Besides that, there had been several circulars through which modifications were made, or formats or disclosure related clarifications were made, and SEBI prescribed different formats for, let's say, takeover open offer related documents like public announcement, detailed public statement, draft of letter offer document, or the other documents to be submitted to SEBI by the merchant banker in case of takeover open offer. So those all small or big circulars have been now rescinded and now compiled at one place in the form of a master circular. So this master circular came with effect from 16th of February. And now we do not need to move around to find the changes in the regulations or the format and in which disclosure need to be made, or merchant bankers need to file offer document or attachments with the offer documents with SEBI, or how to make the payment to SEBI for various purposes like seeking exemptions or claiming exemption under Regulation 10(7), or maybe for payment of this takeover open offer, or all those things. So everything for each these things, there were separate circulars and through which it was governed. Now all those have been compiled in one docket, and we can go there and refer to that for all purposes. So this is a very good move from SEBI's side to make the life easier for all the stakeholders, especially the merchant bankers and other advisors who are working in the field of takeover regulations. So it is just a compilation, no modification, no amendment in any of the regulation. It is just a compilation for the ease of doing business. That is the thing.
Absolutely, Manoj. I believe this kind of exercise should be done for the other regulations also, especially ICDR and other big regulation, especially LODR also, where we are struggling in finding out the data, though the law is very recent one, 2015 only it got implemented, but there are n number of regulations which we have to collate. Many times the non-compliances occur because of being not being aware that what is the relevant last circular, right? So I think this will definitely be
this is a very good practice. Yes, and SEBI is very prompt, very aggressive in compiling, collating, and providing simpler version of regulations also. So they are reviewing all the many of the regulations. They are trying to build whatever the changes, proactive changes or reactive changes have been made in the regulations to be compiled at one place for the ease of the stakeholders. So that's a very good move, and it's happening.
Following the footsteps of RBI.
Yeah, master direction.
Yes. But still, even in RBI case, they have come out with master direction or master circular for limited number of things, but there are still many things for which there are circulars which need to be referred.
But still, I think there are a whole lot of topics on which there is master in RBI.
So all regulators, obviously, as a matter of principle, all tertiary laws like regulations should be as easier, as simpler as possible for the users. it is not, there should not be any scope for interpretation, because this is tertiary regulation law. It should not be the like primary law, which need to be interpreted by court of law. So it should be simpler for the users. That should be the intent. I think I was also happy with the way SEBI PIT regulation, prevention of insider trading regulation, was made. After each regulation, there is explanation. So that kind of thing also helps. So I think that kind of interpretative regulations may be there in future.
But despite clarifications, I think
There are confusions. Yes, yes.
It has become the most complicated
Yes.
the regulation to understand, especially the SDD portion,
Yes.
where we don't understand what exactly is the unpublished price sensitive information, and debates are there. Anyways,
These are something which cannot be explained. There
I
will
agree.
always
I
be some
agree.
sort of
Obviously, in case of TACO regulation, if you talk about the control, it is such a vast subject or such a complicated subject. Even Supreme Court decided not to interpret it. So left it for the wisdom of the people using it.
No, that we understand. I think the purpose of collating and bringing out single circular is that whatever clarifications, whatever subject on which the clarifications had been so far issued by the government, they are available to the users at one place.
Yes, yes.
There should not be confusion with regard to that.
Right.
So moving on, we will now discuss some of the consultation papers that have been issued by SEBI. So starting with the consultation paper on ESG. So recently, in line with a lot of others discussion paper that SEBI issued, one such was respect to the ESG, where there are certain proposals with respect to some additional disclosures on the part of the companies as part of their BSR in terms of ESG core metrics, which has been outlined in the consultation paper. And then there are certain proposals on the side of the mutual funds with respect to their investing in ESG relevant industries and companies, and how they vote as part of their stewardship code on companies in which ESG funds have invested. So whether their investments in any point of time, the decision to invest, a decision to vote in favor or against is influenced by any factor concerning ESG. So if that would be the case, they are supposed to disclose that as part of their disclosure document, where they disclose in what manner they have voted in the companies where they held shares. So and then on the ESG investing in terms of mutual fund, while they invest in terms of disclosure and a lot of other things. So this consultation paper is completely on ESG, but has two different participants. One as a company in terms of disclosure as part of their BRSR, additional disclosures, which generally are required as part of the leadership indicators under the BRSR report, and then on the mutual funds in terms of their voting and their investing. So your views on the same, Amit, starting with you.
No, I am not in a position to make any comment. I think Anjali will be a right person to tell something. That is her forte to explain about. I'm yet to consume the changes with this particular consultation paper.
So this consultation paper is actually very different from all others. Because it has a lot of proposals in terms of quantitative and qualitative data that companies need to outline as part of the ESG report. And then also on the mutual fund, while the proposal with respect to the decision and the factors which influenced voting on companies, specifically for ESG funds, if their voting is influenced by any factors relating to ESG, then they have to outline. I think that is there, but generally most of the cases or most of the resolutions that go for voting as part of the shareholder meeting are in more than 90% of the cases will only be related to one aspect, that is G, because we generally don't take proposals with respect to environment on social related matters before the shareholders. So the only concern that they have while they will be voting in these cases will be with respect to the governance concern. And on the on the company. And so far as I believe in terms of the additional disclosures, though there is a glide path that has been prescribed by them for companies and the class of companies that needs to be disclosing these details. But slowly moving ahead, BRSR will definitely become a very, very important tool to measure economic or environmental and social indicators in terms of the company's performance, because the kind of quantitative data they want to companies to specify in their report, it will be a very important tool to act as a comparative tool between industries of the same class. And even now the BSR which is there, it says BRSR, the BRSR that will be implemented from next year as part of the annual report. If you see, if you compare the companies in same industry, you will get a hell lot of data in terms of how they are active in all these indicators of E, S, and G. So adding more quantitative data and with a glide path, I think once the companies will settle in, they would be in a better position to share more such information on the new indicators that the SEBI wants them to disclose. So going on to the next one, Shiva. So this is important. This is with respect to the listed entities per se. So the first proposal is with respect to the submission of financial results by the newly listed entities as to when they are supposed to file their financial results in case they list during the time when the results provisions are already in force. For example, if a company lists in the month of February and there is a quarter ending result that needs to be disclosed for Q3, or if a company is listing in month of April or in month of May, how they are supposed to disclose their results. So Anjali ma'am, your views on and if you can share some limelight on the proposals.
Yeah, thank you, Ankit. So all these provisions which are proposed in the consultation paper are very important from the perspective of any listed company. In our practice as a consultant, we have seen this query from so many companies that I'm about to get listed, and what would be the first quarter for which I have to submit my results. There was no clarity till now, but now SEBI has proposes that the confusion that used to be there is, so say a company is getting listed on 10th of February and the last date for giving the results for December quarter is 14th of February. So is it needed to give the results within those 4 days? It's very difficult for any newly listed company to give the results. Likewise, it was being felt that a company which is getting listed on, say, 10th of February or 1st of March, and by and large they would have given their results up till the quarter ended September 22 in their prospectus. So then what would be the period for which next results have to go? December ki results, are they required to give by 14th, or if not by 14th, then by when? So SEBI has clarified that within 15 days of the listing, it is proposed, these are all proposals, these are amendments are yet to come, but in a normal language, we are saying that it is proposed that within 15 days of listing, the company has to submit the results. Likewise, in a situation wherein a company is getting listed on, say, 1st of March, then the requirement of filing the results would be as per the normal regulation 33 period, that is within 45 days from the end of the quarter, or within 15 days, whichever is later. So SEBI has tried to bring in a parity in submission of results. Likewise, the second provision with regard to filling up the vacancy that is created in the office of director or compliance officer or CEO or CFO of the listed companies. While the provisions, listing regulations very clearly talk about the provisions with regard to filling up of vacancies arising out of resignations, etc. But in case of death or disqualification, there is no time limit given that within what time these kinds of vacancies have to be filled in. It is proposed that again, within a period of 3 months, this vacancy has to be filled in. Then SEBI has in the discussion paper mandated 2-3 situations in case of which this 3 months period would not be applicable in the sense that number one, in case there is a change in the designation of a particular director from independent to non-independent, or tenure gets over. In those scenarios, the 3 months would not be applicable because it is presumed, it is understood that the company is well aware that this situation would be arising, and it is proposed that in such situations, the company has to appoint the director or fill in the requisite position on the same day on which this vacancy arises.
And I believe
Now, coming to the company secretary or other
audible
KMPs
to you?
of the company, although the Companies Act gives us a time frame of 6 months to appoint a particular company secretary or a KMP, other KMP, but in case of a listed company, it is felt that 6 months is a very long time, that these companies go without a compliance officer or without a proper CFO. So it is again proposed to fill in the vacancies within a period of 3 months itself, of any such resignation which happens in these offices. Now,
on
in case
the
of
ma'am, on the independent directors in clarification, I believe there was already a general understanding that this period of 3 months or the next board meeting was not available when it was on account of some action on the part of the company.
Right.
Whenever it's all on account of the part of the independent director, either on account of death, where the company cannot do anything, or on account of resignation, this period was not available. And I think by way of this amendment, the only thing that is amendment is trying to bring is clarity in terms of you interpret, so that the companies which are taking an otherwise view, there is a clarity that any action on the part of the company where this non-compliance is triggering on the composition, then you don't have that period of 3 months. And then on these other CFO, CEO, LODR, I think now, if you see the entire LODR in most of the ways on course of conflict with the Companies Act, because under the Companies Act for all the KMPs, MD, CFO, there is a period of 6 months that has been provided. Now for even those 6 months for listed entities, they are trying to bring a new period of 3 months. So in new set of proposals are also said to be in a way conflict with the provision section 203. Though considering a listed entity, 6 months is definitely on a higher side, and a company should not be having so much time. But at times they take, specifically in case of intermittent vacancies, they do take time to find out the suitable candidate. But what also needs to be looked into is that where this vacancy is arising on account of superannuation, will still the period of 3 months will be available, because it only says any vacancy. So vacancy can also, it doesn't uses the word intermittent vacancy as opposed to in case of independent director. In all these cases, it has to be vacancy, though even in case of superannuation, companies are fully aware as to.
Yes, but if we go through the language of this particular regulation discussion paper, it seems anything of which you are aware of, the 3 months would not be available to you.
But the point what Ankit is highlighting, that in respect of KMPs, this position is not very clearly appearing in the document.
It is still, they've only used the word vacancy. So vacancy will in case anyway comprises of all these cases.
And also a second question, that will there be a concept of acting compliance officer, because who will do the compliances during that period? Because up till now, the stock exchanges, I am privy to many companies where the stock exchanges have issued the notices, and even the fines have also been levied, even in those cases where the vacancy has not been filled within the period of 2 months.
And I think there has to be
they are of the view that you can't have a situation where you don't have a compliance officer, company secretary as a compliance officer, right? So now point is that if there is a vacancy. Now, legally, we can have a 3 months period where the company secretary cannot be there. Now, in that period, can a managing director, can a CFO be nominated as a compliance officer? Because company secretary, because the regulation LODR says that company secretary only will be a compliance officer.
But we have done in some cases, have appointed interim CFO as an interim compliance
Yes,
officer.
we have done that. Yeah.
Because though the regulation doesn't create a window for such appointments, but where companies they don't have a full-time company secretary, even as a junior company secretary to the main company secretary, those companies find it very difficult. And for example, under the code of conduct, generally compliance officer is the compliance officer of the company. So for processing those requests, there are a whole lot of things where things come and get stuck at the end of the compliance officer. So I've seen companies, and we do also advise them to appoint at least the CFO as an interim compliance officer for the time being, irrespective of the fact that he is not a company secretary, because there is no other time gap arrangement that they have allowed for. And they should, considering they have now given you a period of 3 months to appoint the compliance officer. During this 3 months period or intermittent period, there has to be some provision for appointment of an interim or a temporary compliance officer.
I think that much clarification may be sought from the SEBI or the
I think
suggestion.
as part of this discussion paper also.
6th of March is the last date to make a comment.
I think last one is important, I think, ma'am.
Yeah, this is a very important point, and I would want a full panel discussion on this point rather. Freezing of the demat accounts of the MD, whole-time director or CEO of the company in case of any continuing non-compliances of LODR or non-payment of fines. So under the present norms, we know that only the demat accounts of the promoters, not even the promoter group, only the promoters are frozen. But this is a very far-reaching step which may be taken, in the sense that even the demat accounts of the CEO or the whole-time directors or MDs may be frozen. So probably this would I agree, SEBI intent is to act as non-compliances. These should act as a deterrent. But ऐसा नहीं होना चाहिए that people feel afraid or people feel scared in becoming the directors or assuming the positions of these of listed entities in case of any such thing continuing. Your views, Ankit, Amit, Nikita,
I think to be starting with, it should first fall on the management and then go to the promoters. I think starting straightforward from the promoters on freezing their accounts in case of compliance.
No. But the reason behind it, by the initial discussion papers which came and wherein the freezing of demat accounts was proposed, it was that since through the promoters only, all the decision make, all the payment of penalty and everything is flowing, and in case the person at the helm of the affairs is saying, let us continue to be a non-compliant company, what would the poor company secretary or the CEO would do?
See, this point, what Anjali ma'am is trying to highlight, I think is very valid. Reason because the company management may not have actually control in respect of certain compliances as such, right? Maybe let us say you are doing a non-compliance of minimum public shareholding, or maybe there are other non-compliances which are controlled by the promoter. So there are two sets of non-compliances which we need to understand. So if it is on account of actions or inactions of the management, there I understand what you are saying is making sense. What Ankit is saying is that the management and CEO should be the first person whose demat account should be frozen. But when we understand that in majority of the situations, the management is not having, but there are two type of companies where the professional management is there. The management generally don't have any significant shareholding also in that particular entity. On the other hand, the promoters are largely having major shareholding, and they are the one who is controlling. My point, I think, where I am in agreement with Anjali ma'am is, in first instance, I am not in favor of extending this hardship to the management at all. Secondly, the second part of the proposal, which says that even if a new person who has joined the company as a managing director, CEO, after expiry of 90 days, his account will also be frozen if he fails to comply or rectify the position within that 90 days. So now, my company, if I have joined that company as a managing director, I get a very limited window to understand as to what all. So my focus is to understand and run the company. And now, in addition to that, I fall in a prey that my demat account also all of a sudden got frozen because there was certain non-compliance, which might be not due to my default. I think that is little harsh. Maybe the idea is that they want to sensitize to the new management or put a responsibility on them to make a compliance, right? One point what I wanted to communicate is where SEBI has done SOP based non-compliance calculation, and from there only these kind of freezing of demat account provisions are also coming. The circular that is issued, I think last one was somewhere in March or April 2022, which is now in force, which talks about that you have to deposit the advance money if you want to go for waiver also even. Now, if you have standardized that SOP, but when it comes to making a discussion on these adjudication processes, whether the penalty is actually leviable or not, the matter is lingered on for months. It is not decided. So unless and until, because if I have a confrontation, I'm saying I am in compliance, you are saying you are not in compliance. During that period also, if my demat account is frozen or I am continuously on the pressure that if I don't pay, then my account will be frozen, is not correct.
I agree with what Amit is saying. It actually takes a very long time for any of the outcomes to come that the penalty has actually been waived off or not.
So the bottom line is that because in many cases, the penalties are being cleared or paid just to avoid the freezing of demat account of promoters. No management, no company secretary, no KMP dares to take an action which goes to the promoter, freezing of demat account, right? So in many of the situation, I think this is being now used as a tool by the stock exchanges to recover the outstanding money to clear. Otherwise, they threaten that this money will be, this demat account will be frozen. Means to that extent, means in genuine cases, I don't mind.
Amit, not a tool. I mean, the original idea was it should act as a deterrent for the companies, that they should not think by not complying there is a solution. If you will not comply, there are penal provisions or there are legal actions which may be taken against the company or the promoters. But this provision, I am of the view that would be little harsher.
Thank you. Thanks for the discussion. I think we should now move to the next discussion paper that also concerns the listed entities.
In fact, there have been almost 16 consultation papers issued by SEBI during last month. Of course, we could not have taken all the discussion papers here. We have tried to take the important ones, but 16 means that SEBI is wanting that everything should be streamlined in one go and the things should be in place. So now, with regard to the corporate governance provisions, there have been certain provisions, certain proposals which are there with regard to the agreements which are there in place by the companies or by the promoters, or with regard to the any scheme of arrangements which are being undertaken, or even in respect of board permanency in case of listed companies. Shivam, next.
Ma'am, you have this slide.
Acha. Okay, fine. So it was being observed by SEBI that in many of the cases, companies were entering into agreements with outsiders, third parties, and in many of the cases, even the companies were not entering into such agreements, but the promoters were entering into such agreements, wherein there is a negative impact on the control of the company or on the or management of the companies, and public was not becoming aware, public was not getting aware of any such contract becoming effective. So it is proposed that any such agreement being entered into is needed to be disclosed under Regulation 30 of the listing regulations for the dissemination of the public at large. And simultaneously, it is also proposed from next financial year that any such agreements or any such disclosures made should be made a part of the annual report of the company as well, so that public is well aware that any such agreements have been signed by the promoters or by the company. Then
I have 3 points to discuss on this.
Yeah.
So first is with respect to the agreements. Now, one thing they have clarified that any agreement which affects the management and control
right.
has to be disclosed irrespective of the fact whether it is in ordinary course or not. Currently, ordinary course agreements are not required to be disclosed. Secondly, they've added a new restriction, new clause or a new point with respect to agreements which create any kind of liability, which was not there earlier. Earlier, management and control was there, but now they've also added a new point, creation of any kind of a liability on the listed entity. And the third point that they have also sort of clarified that even though these agreements are entered by any third party, irrespective of the fact whether the company is party to that or not, has to be intimated to the exchange. And they've also come out with a mechanism how these companies, within how much time these companies will accordingly intimate it to the company first, and then company will accordingly intimate to the shareholders. So what is I think important is with respect to the word create any liability. So we also need to understand in what kind of cases this liability may be created and which may have an effect on the company, because third parties, they might create liabilities in terms of their shares in the company by way of pledging, or whenever there is a like for example, I take a loan and I create a subservient pledge or charge on the assets of the company. I believe those cases will now also fall under these disclosures, which otherwise are not required earlier.
I think guarantee contracts where
guarantee contracts or third party charge contracts on the assets. But in generally all these cases, though company is also a party, but since it creates a liability, all these now also required to be disclosed. And another important point is with respect to the requirement of obtaining shareholders approval, both with respect to the existing agreements which fall under this criteria and the proposed criteria, where the concept of majority of minority they've also trying to introduce. So in a way, seems a good move, a good proposal. Anything which affects a company should be at least by its shareholders. So seems a good move. You can move on to the next proposal.
Totally agreed. Further in the Shivam, 1 second, please go back. Yeah, and in addition to the these things, the other thing that SEBI observed that in the new age companies that are getting listed, there are certain special rights which are available to many of the shareholders, and in many cases there is a board permanency wherein a particular person has a permanent seat on the board. So it is also proposed that there cannot be anything permanent. You have to take shareholders' approval. SEBI has proposed that once in 5 years, you have to take the shareholders' approval for any such special right being conferred on any particular person or any permanent seat, any board permanency seat being there. So once in 5 years, the shareholders' approval is needed to be undertaken. Shivam, next.
And on to the, have we discussed on the, I think the asset thing also needs to be discussed. The third proposal, where they are now also bringing or proposing a requirement of majority of minority with respect to sale of assets. The term undertaking has been used in reference to section 180. So where there is a concept of you need to take a special resolution under section 181A if you want to enter into a contract or arrangement where you are selling, leasing, disposing of your undertaking. Then apart from the special resolution, they are now also trying to bring a concept of a majority and public, majority of minority, and the share board is also required to give a detailed rationale behind the proposed transaction. So these are the key proposals that forms part of the this discussion paper. I believe both the discussion paper, the last one and these discussion paper, some proposals are very, very practical, and I don't see any objections to those proposals. And generally, once SEBI decides something, it is there as part of the law sooner or later. On to the last one, the consultation paper on the ICDR regulation.
ICDR regulations. So there are certain provisions which are proposed to be brought in with regard to underwriting, and in case of a bonus issue, and in case of inclusion of pension funds to be able to participate as anchor investors, and inspection of material contracts. These are the 4 points majorly covered in this particular consultation paper. So with regard to underwriting, it has been proposed that in case of issues which are proposed in case of IPOs and FPOs through other than book built methods, if the issuer wants the IPO to be underwritten, it has to enter into an agreement with the merchant banker or the stockbroker. And before filing of the DRHP, an agreement is needed to be entered into with these agencies. The agreement has to specify as to what numbers the underwriter is underwriting to, the merchant banker or the broker is underwriting to, and at what price would they be taking up the underwritten shares. And in case of book built issues, it has to be underwritten by the lead manager or a syndicate member of the lead manager. Now, with regard to the bonus issue, it was observed by SEBI that in some of the cases, there was a mismatch in the listed and the paid up capital of the company. And as a result of which, they used to announce the bonus issue, but because of the mismatch, the bonus shares being allotted were not getting the trading approvals within the mandated timelines because of the exchanges move in chronology of the distinctive numbers or the allotments made. So it is proposed that before announcing any bonus issue, the company should have obtained in principle approval for all the pre-bonus capital. Then only a company can announce the bonus issue. In my view, only in principle approval may not suffice this purpose, this requirement. It should be there should not be any mismatch in the paid up and the listed capital of the company. This should be one of the basic preconditions which should be made a part of the bonus chapter. Secondly, simultaneously, in the present scenario, in case of people who are holding shares in physical, bonus allotment is also made in physical form. But now it is proposed that no allotment in physical would be made to anybody. Even for people who are holding shares in physical form, bonus allotment would be made to them in demat form only. This is it. And with regard to it is proposed that pension funds sponsored by the entities which are associates of lead managers should be allowed to participate as anchor investor in a public issue. And the last point covered in this discussion paper is that whatever material contracts or material documents form part of any offer document should be available not just through an offline inspection, but also should be available through online means by way of an inspection. Then any industry reports which the merchant banker is relying upon in the offer document should be made a part of the material document for inspection. Simultaneously, all the material documents should be uploaded, the offer documents should be uploaded on the website of the company. Although we still do that, all the material contracts, everything we still do it, but still the SEBI might have noticed certain cases wherein this requirement was not being met with. So now it is proposed that it will be a mandatory requirement. These are the broad parameters, broad points of the discussion paper.
Okay, thank you, ma'am. There are some questions we have received. Is this MTS condition applicable on PSU companies?
Yeah, it is.
It is.
Yeah.
Amit, there is a question when the freezing of
Just to add, I think the condition of requirement of reaching out, there was a modification in the Securities Contract Regulation Act for the public sector, and the requirement was kept at 10% threshold instead of 25%. So that still continues, and that time period has been extended further. I think that requirement which was saying that this will be required to be extended to 25% minimum public shareholding has been taken back. So as of now, there is no timeline, and PSUs are allowed to continue 10% minimum public shareholding.
Okay.
Right.
Another question is freezing of demat account is the word used, whether it means all is demat accounts or that which pertains to the listed entity.
All.
Ma'am, I don't think you have, there is a question on the SEBI Securities Contract Regulation Amendment Regulations, amending the definition of KMP. Please, if you can elaborate the effect of the same, and in particular to include the in KMP reporting officials of the KMP. Does it refer to a person to whom KMP is reporting or a person who is reporting to KMP? I believe reporting officials of the KMP is the term which is used.
Reporting officials, I don't know. I mean, there was this amendment in this wherein the definition of senior management was changed.
Yeah, no. So this
But,
definition
this
amendment was this. The question is on the Securities Contract Regulation.
Right.
We'll come back on this, Mr.
We'll come back to you. Yeah.
On this question, we'll reply you separately on this. Shivam, if you can just take a note of this, and we'll reply them separately. There are some questions on the technical issues of MCA. I don't think we are the right forum to discuss that. So no other question that needs
on MCA part, Ankit, I just wanted to highlight, maybe we need to make another representation, because only 45 forms have been put into the category of fee extension, right? There are difficulties like forms like charges, right, which are very, very key for the running of a business, right? If you go for taking a borrowing, then you are not able to create, if a charge, then money disbursement at all is at a question, number one. And that form has not been given any extension. And the issue in case of charges related form is that after 120 days, you cannot even file also. That is permanently blocked. And there is no time extension. And that form is in V3. Whether any other form is there or not, but at least the charges related forms are required to be there. I don't know whether somebody has faced that difficulty or not, but we need to make that representation. Number two, in general, I'm saying because of this problem, all other filings are also affected, right? If portal is not working, maybe why my only forms which are due during 20th of January to 28th of February only are being exempted. Why not the other forms also? Because portal is in any case not working. If my
I think it has to be a blanket.
I think yes,
March,
the MCA should give that this period will be excluded in all form filing. Simple and straight. Nothing more than that. If their website is not taking the forms, simply say that this period is not counted towards the timeline, whatever timeline it is.
It is not available for new forms also and for old forms also.
Yes.
Company unnecessarily is suffering because of all these things. So I thought I'll just
Ex-office bearer, you are in a better position to take this with ministry. We are just like any other professional.
so
We'll
maybe we
try
can
to
make
talk to the current system.
request to the ministry again. Although many requests have already been there, but again, something further is required so that ministry can hear it out.
Thank you. I think thanks everyone for participating in today's webinar. We have a fruitful discussion. Thanks Amitji, thanks Anjali, Manoj, Nikita, and thanks everyone who was still there and listening to the deliberations today. So we'll meet again next week, Friday, same time. We'll disclose the topic of the webinar next Friday very soon, most probably early next week. And till then, take care and wish you all a very, very happy and colorful Holi.
Thank you, Ankit.
Thank you. Thank you, Ankit. Thank you.